I'd like to call our meeting to order and begin with the Pledge of Allegiance. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
So this will be a simple meeting, I guess. Since we have no applications, I guess I don't have to go through the process of saying what we typically do. And anyone in the audience, I guess it's all friendly comments here. We've just got the two items on our agenda, which is reviewing the minutes and listening to our city attorney provide us with some information on our planning responsibilities. So the first thing is the approval of our minutes from our May 13 meeting.
I move that we accept the minutes as presented.
Actually, I have a comment.
Oh,
before we do
okay.
that. Anyone else have a comment? No. So my comment in here, there's a comment that's attributed to me, but it's really out of context because I'm replying to a question that was raised by the city attorney. And there's no reference to the question, and so my comment doesn't really make a whole lot of sense. So I just took this right off the recording. And this actually occurred, we had the resident here that was explaining her concerns with her views of the site and her concerns. And immediately after that, and actually I think David offered that there was permission for the trees that were removed. And right after that, I started summarizing things, and then the city attorney interjected, and I'm just going to read this. This is right off the recording, because this is what I responded to, and it's not in the minutes. So it says, City Attorney Roberts inquired how the discussion relates to the two items under consideration by the commission, which are the proposed side yard fence and the cuts and fills. That was the question, and then I responded. Commissioner Cuter explained that the applicant is proposing a massive regrade of the site with 10-foot fills and building walls to support the fill placement. The walls do not meet the definition of retaining walls because they are supporting placed fill material. He noted that the city code is clear. The city does not promote changing the site to fit the home. He also noted that we need to be cognizant of the neighborhood, and we are trying to protect the neighbors by providing screening. So that's what I said, and I guess I'd like that in the minutes. And together with the question that I was responding to.
Is that a motion to amend the minutes to reflect your?
Yeah, I guess, yeah.
I'll second that.
Okay.
Any other comments or anything? Okay, all in favor, say aye.
Aye.
Any opposed? Okay. I guess the next thing then is just, Mark, if you want to take us through your presentation.
I was told a good way to start is to hand stuff out, so if you want to take one and pass it down, I'd appreciate it. Just wanted to talk briefly. I don't think we'll take a whole lot of time here, but I do want to cover a few things and start kind of with the basics. What is the design of the Planning Commission? I mean, it's set forth in the code 1318. It's a 9-member commission. There's 3 ex officio members, which means it's designated officials, the mayor, administrative official, and a member of the city commission. And then there's 6 people representing different professions or occupations that are prepared, that are supposed to be members. So why? Why do we land on this design for the Planning Commission? And I think it's consistent with kind of the basic form of government that we have in the United States, is that decisions made are made as committees instead of by one person. You draw from a wide variety of perspectives in hopes of reaching the best decision that is possible, and I believe that system has worked well in the history of our country, and I believe that's the purpose of the design for the Planning Commission. Drawing from different perspectives, everybody reviewing things and then gathering together as the commission to hear presentations, discuss the matters amongst themselves, and reach the best decision possible. So that's kind of the basic principle and the basic design. What's the purpose of having the commission and the design of this commission? The purpose is also spelled out in the city code in 1325, and it lists subsections A through J, all designated tasks of the Planning Commission, but they really revolve around a few critical features. One of the first important functions of the Planning Commission is you kind of develop the goal of the development of the city, the future of the city, and that's reflected in the master plan. So you oversee the master planning process, and when it's time to revisit the master plan, we'll delve into that in greater detail, but it entails a group of public interactions where you draw ideas from the public, concerns from the public, areas of concern. You deal with your planning consultants, and you put together the master plan for the city, which is kind of the goal that we're striving toward. The master plan itself is not a regulation. It's the basis, kind of the goal where the regulations are hoping to take us. So from the master plan, the other function of the Planning Commission as it relates to the planning tasks is the development of a zoning ordinance or zoning ordinance amendments, as the case may be. So you can draw ideas from the master plan for developing the zoning ordinance, but also, even though we're not in the master planning process, I put it to you that the Planning Commission and the ZBA to a certain extent as well, keep track of what comes before you. Keep track of what the issues are that are being brought forth. And then take a look at the ordinances that we have in place. And if there's areas of improvement that you see in the zoning ordinance, that's a function of the Planning Commission. Either receiving recommendations from the City Commission, who controls, basically everything in the city is under the City Commission. But the Planning Commission can take direction from the City Commission. It can take direction from people speaking at public comment from the ZBA, and evaluate those and apply them to the existing zoning ordinance. And you may find that perhaps an amendment to the existing zoning ordinance would be in order. And there's a process involved in that, and you follow the process. You conduct a public hearing, you propose that, and then you make the recommendation to the City Commission one way or the other, either to amend or to leave it the way it is. The City Commission is the authority. So the Planning Commission doesn't adopt a master plan. The Planning Commission does not adopt a zoning ordinance. The Planning Commission does not adopt any amendments to the zoning ordinance. But the Planning Commission serves a very important function to assist the City Commission in making decisions regarding the zoning ordinance and the planning perspectives of the city. and that's a very important role of the Planning Commission. And probably not a role that is often exercised, but it's something that should be kept in mind as you're going about the other tasks. Because, like I said, there's instances where an issue may come before you in an application for an improvement, and you notice the ordinance doesn't really address it. Maybe it's something relatively new. Maybe it's just a different perspective on something. And you see something in the ordinance that could be clarified or changed depending on what the issue may be. And then you follow the process if it's determined that you want to make a recommendation to change that. One of the other functions of the Planning Commission is reviewing certain proposals for improvements made in the city. And they range in complexity from, you know, a relatively simple single-family dwelling improvement up to commercial developments or whole subdivisions involving site plan reviews. So there is a range, and each one is driven by the ordinance code. And in applying those, you're given the authority to make these determinations and assessments, and that authority is derived from the City Commission. And the City Commission is exercising its authority that it has been given to it by the state under the Zoning and Planning Enabling Acts. But it's important to recognize the limitations on the Planning Commission. As I indicated earlier, the Planning Commission is not the one that actually adopts policies. It's not the one that adopts ordinances. But the Planning Commission has a role that's been dictated to it by the zoning ordinance and the ordinance code of the city. And it's important when reviewing what I call the quasi-judicial aspects of the Planning Commission, where you're passing judgment on an application for an improvement. You're bound by the terms in the ordinance code on what matters you can determine. And by way of example, and the handout I gave you is a brochure that's got several of the ordinances that I believe you more frequently are familiar with and faced with. And just by way of example, in the grading ordinance, I believe it's 7.9, is dealing with your role as evaluating and deciding appeals from decisions on the grading ordinance. In the grading ordinance, in subsection 9, the appeal section, the Planning Commission shall have the power and duty to hear, decide, and grant or deny the request for a grading permit where, and then there's 3 criteria. Those are the criteria that you should be focusing on when dealing with a grading appeal. And that's set forth in the ordinance. That's the authority that is granted to.
I'm sorry, can you take a little more time to actually show us what page you're referring
I'm
to?
Yeah,
sorry.
can you?
I'm sorry. It's actually in chapter 7.5, the grading,
5, 5 and 6, final grading approval, or?
and it's the last page. I'm sorry.
Tab 2, page 9 of 9.
Tab 2?
Oh, tab 2.
Yeah.
To page 9 of 9 or 6?
And it's the last page
9.
of subsection 2. And the prior page is 7.5-9 appeal. And the area that I'm focusing on is the paragraph on page 9 with the 3 bullet points, the 3 subsections underneath it.
And for those commissioners who were absent at our last hearing, can you reiterate how you are not interested in what the master plan of Bloomfield Hills, that we shouldn't be quoting the master plan, with regard to, in the city of Bloomfield Hills, the master plan is that not only do we not want fences, but that we want to have, the house built to the property, not the property to be changed for the house being built. And you took issue with that, because you don't want us to quote the master plan at all, you want us just to quote this particular grading thing? You don't think the master plan has any weight in that? Are you still of that mind?
I am of the mind that the master plan is not the regulation that you're enforcing. Okay? The master plan is the goal that's developed with the assistance of the Planning Commission. Recommendations are made to the City Commission. The City Commission is the one that adopts the master plan. The City Commission then, well, let me back up. The Planning Commission, in addition to the master plan, also uses that master plan to develop the zoning ordinance. And the zoning ordinance is the regulation. So the master plan's the goal, the zoning ordinance is the regulatory authority to reach that goal. And so the Planning Commission, when it develops the zoning ordinance recommendations to City Commission, it uses the master plan goals and establishes regulations that, in its opinion, will reach those goals ultimately.
Okay,
So
so
the master
under
plan-
equal protection of the law, all of the people who have come before this thing who've been told, I'm sorry, you can't put in a 10-foot retaining wall, we don't do that in the city of Bloomfield Hills. And now you're saying to the Planning Commission, they don't have that authority to do that? That we don't put 10-foot fills, we don't change the grade by 10 feet? And I've watched this, you've only been to one hearing, but I've watched this happen many times in these Planning Commission hearings. You're saying that there is no ordinance behind that? There's no precedent? There's no common law?
There's the grading ordinance that
So-
regulates fill and
So
changes
no
of grade.
precedent, you just want us to stay in the box of this particular subsection when we're deciding on a grading thing? That's what you're advising?
This is what the City Commission has passed as the zoning regulation that you are to apply.
And the city
The
commission
commission has
also passed
also
the master
asked that the
plan,
planning
right?
commission respect precedents and respect the master plan.
That is how
Understood.
that's how I've been taught to function here, to respect what the city commission and all of these people who've served on this board for 10+ years, who worked very hard on this master plan, and they've worked very hard on treating every single individual in here equal to the one who came before. It doesn't matter if they're
Exactly.
an ambassador or a polk or anything. Everyone gets treated the same way. Based on the master plan, based on the fact that we all live in the city of Bloomfield Hills and we want to keep the character that they've worked so hard on in the master plan, we make decisions with regard to that too.
Right.
Just like judges do.
Right.
Can I,
And when there is an area of the law that doesn't address some of the criteria that you feel need to be addressed, then you start the amendment process to amend the law, in this case your zoning ordinance, to reflect the fact that these are additional items that we're going to be regulating. So for instance, if your zoning ordinance, apparently you don't feel it covers everything that it should cover in the master plan goal, then I would put it to you that it would be appropriate to consider amendments to your ordinance to address those and develop those further as the Planning Commission, amend your zoning ordinance, recommend it to the City Commission. Then if the City Commission adopts those amendments, then not only are you treating everybody the same, because now you're following what's set forth in the ordinance itself, you're not relying upon precedent, it's set forth in the ordinance, so that people, when they're planning to do something on their property, can look at the ordinance code and see how they're going to be evaluated. As it stands now, somebody looking at the ordinance code that's making plans is going to be looking at the ability to appeal a decision based upon the granting of the grading permit would not materially detrimental to other property owners in the vicinity. Any unusual conditions applying to the specific property of the applicant do not apply generally to other properties in the city. Strict application, I mean, you can read this. This is what they're going.
I'm fine with that, but what you're doing is saying that maybe your role as the city attorney, the new city attorney, is to show where the planning commission have treated everyone equally, the same when they come in here, but we are missing parts of our ordinance, and that you should point out where we need to propose and add to the ordinance so that we can treat it the people.
Can I
I'm
just
perfectly
interrupt?
With that-
willing to do that,
Yeah,
yes.
so you're finding the holes, because you're in court trying to defend,
Exactly.
okay.
And I want to make sure when I'm in court defending, it's based upon ordinance language, which is going to be applicable. That's what's going to be enforced by the court, is what the ordinance says. The court is not going to go back through past minutes and try to
precedent.
establish precedent. This is not like a court case where there's reported decisions throughout history that judges go back and research case law. That's not how this works.
Can I offer this? So, Attorney Roberts is in the middle of this presentation, and I guess there's probably some benefit to let you go. But to Katie's point, if you look at our ordinances, if you type in master plan, you're going to get about 30 different hits for those words. And in fact, our ordinances rely, they actually refer, and I don't have my computer right here, but if you type in master plan, you'll find, I think like in our design standards, it says, and it may not be the design standards, I know it says it in like the subdivision portion of our city code. It refers to doing, completing improvements in conformity to our master plan. And we've always followed, for as long as I've been on this commission, and this dates back to your predecessors, we've always included references to the master plan because, to your point, that's not the law. However, it does set the parameters for what we're doing, and
Which is what I'm saying.
and the other important part of that, and our planners could actually speak to this, is continuity, following the precedent that's laid out in your master plan in terms of staging development from corners, where you go from commercial to less intensive to less intensive. Every zoning meeting, when I'm sitting on the other side of the table, I've ever been involved with, we've always made the master plan as a foundation for rezonings. It's a principle.
Yes,
It's just.
Yes.
So I think just to let the discussion go further, but to Catherine's point, while it's not the law, it is a guiding principle, and we need to adhere to our master plan, and it is fair to refer to our master plan in the application of our ordinances, because it's actually embodied in the ordinance, it says master plan, so maybe.
It does say master plan in various sections. And that's because the city commission, in adopting the regulation contained in the zoning ordinance, is saying to the planning commission, when you're dealing with this, look at the master plan. When you're dealing with a subdivision development, look at the master plan, to use your example. I don't believe, and I haven't particularly studied it, but I don't believe your grading ordinance has a reference to the master plan. I don't know that for a fact, but but my point is still the same. The master plan is the guiding principle. It's not the regulation. And that's my point. When you're dealing with applications before you, you have to confine yourself to the regulation. If the regulation is inadequate, then you need to look at amending the regulation. That doesn't mean you ignore the master plan. It's the guidepost, it's the standard, it's the goal. You don't ignore it. But you don't base your decision strictly on a master plan because you're bound to follow the regulations contained in the zoning ordinance.
Counselor, when that individual came in here, for whoever wasn't here, when the individual came in here and proposed that he would do X, Y, and Z on a property, and everyone was like, well, could you change this and put this tree in, and could you change that and put that tree in? I contend he had no right to be here. He was not hired. He was actually not a representative. That was just false. He should have never been scheduled to even be in here. We were as polite to him as we could be, but he should not have been in here. He was not a representative. He was not hired.
It is my understanding that he was the representative, but it's not my intent.
So there's no ordinance for him when we turned him down, right? There's no ordinance in here. I can't say a section to help you in court. I can't point to an ordinance and say, you really shouldn't be in here telling
Let me, so we can move this forward.
I really don't want to get bogged down on addressing one case, because that's not really the intent tonight.
I'm
But
asking, you've only been to one
Guys,
planning commission.
guys.
And in that one planning commission, I was turning him down as nice as possible because he really was not even hired. So how does that screw you up in court? What should we have said differently?
Can I propose this? I'm still, well, I'm not leading the presentation, I'm still the chair here. So, some of Catherine's points, I mean, they're relevant. I think let's just agree to this without diving into a particular application. I think the commission should be left with the understanding that the master plan outlines the principles of the city in terms of its overall development. If you look at the master plan, there's 3 people listed as people that drafted that, and I was one of them. So I know what's in the master plan and know what the foundation was for the master plan. The master plan is referred to in many of our ordinances, and while it's not the law per se, because the law per se is embodied in our ordinances make many references to the master plan. And so maybe our takeaway is, as we move forward, we ought to consider our master plan. Every community does. And in the application of our ordinances, what we need to do is look at the rules per se, and understand how that intertwines with the master plan, specifically if it's actually referenced as it is in, I don't know, probably 2 or 3 dozen different cases if you type that in. It is not in the grading ordinance. However, to Catherine's point, there was discussion about installing landscaping. And I actually sent out after the meeting an email on this. And what this gives the planning commission the authority to do is a broad range of things, basically to make it right for the neighbors. So when there were commissioners that raised issues about installing vegetation, it was done on the basis of this language, which is really broad in terms of, I don't know where those 3 points are, but it speaks to,
Well, that's in this ordinance, where it says the
Yeah.
grading permit would not be materially detrimental to other property owners.
yeah, I mean.
In the vicinity, so.
Yeah, right, so, and that was that specific issue. The neighbor complained, and then it says, in granting the grading permit, the planning commission may attach thereto such conditions as it may deem necessary to carry out the spirit and purpose of this chapter in the public interest. So, it doesn't get any broader than that. You have to be reasonable, but, so bottom line, so we can leave this conversation, the master plan's important, the ordinances are important, they all sort of intersect together, and maybe we move forward onto
We
the next
move
subject.
forward, we move forward with the concept that the master plan is not the regulation.
And that's what I
I'm
think I
not
said.
I'm not saying it's not important. It's not what I'm saying.
Okay. Would you?
And the reason for the master plan, you touched on it. One of the things you rely upon the master plan for is when you're talking about amending your ordinance. You rely upon the master plan to amend your ordinance. You need to amend your ordinance to be consistent with your master plan. That's the function of the master plan. If your zoning ordinance in sections specifies follow the master plan, then you follow the master plan on those criteria. But if it's silent, what I'm suggesting is the regulation is what you follow. If there's something to be interpreted in an ordinance, you can look to the master plan for interpretation, but you're applying the regulation. That's the point. And I
think
don't
we're-
really think we're disagreeing on that. I think we're saying the same thing. So,
I think we're good. I think we're
does that
good.
make sense?
I think we're good.
So then there's, as I indicated, there's a couple different categories of functions of the planning commission. One is the quasi-judicial function, which I think most people are probably most familiar with, because I think that's what you function mostly under, dealing with proposals like we were just talking about. And I've got suggestions. This is not a requirement, this is just a suggestion. That when you receive the agenda packet, go through and study it, get familiar with it, at least get on Google Maps, maybe get a view of the property, maybe drive by it, you know, whatever you're comfortable doing.
So you know that there's not law cited in those things that Eric writes up that you wanted us to quote the other day. We can't cite what Eric puts in there. He's a layperson. He's not citing that, but if you want him to cite the actual laws that apply, we will refer to it in there. I just don't know, telling us that we should go to the sites and check them out. We're coming in here, so you, who have been to one meeting, can tell us that we should actually go look at the houses and make sure we're familiar with what every one of these people have put in hundreds of free hours to go and look at sites and talk to neighbors and talk to heads of neighborhoods. I understand you coming in here and saying, you guys are leaving me hanging out to dry when I go into court and I'm trying to defend something. You need to amend your laws. You need to start citing laws. I understand that. But coming in here and telling these people who have been working on this commission for free for over 10 years how to do their job with regard to how much time they should put into it, when they do, I'm aghast. I really, and you know what? If there's something wrong with our ordinances that we're not referring to the master plan that you've deemed, shouldn't you be coming into the city commission and telling them you need to fix your ordinances because you're leaving me hanging out to dry when I am trying to defend your ordinances? You need to fix these things instead of telling the planning commission, who have absolutely no ability to change ordinances. But now you're gonna tell us that we should read and prepare for coming in here? Every single one of these people does that. But you wouldn't know that because you've been to one meeting.
Guys, let me offer this. I think it's fair to understand that everyone sitting at this dais has been on this commission for a lot of years. I'm not that old, so, but it's fair to assume that we walk into this, and with all due respect to you, Mark, you don't know us as a group, but we've all participated in the preparation for coming to the meetings. So, and I think the fact that you're doing this is great, but just as a preface, we've already sort of been there in terms of we know we go through the preparation. So, but it's fine to offer that, and that's fine, Katie. I mean, if,
Well, just
So-
move on
I
to your,
don't mean
move
to
on
be
to your next
insulting.
thing.
I
Let's
really
move on
don't
to your
mean to
next
be
thing.
insulting.
so let me
Okay.
suggest this. We'll just continue, let's just listen, but know that, I think.
All of us
Susan's-
do that, Mark. We all go to the sites. We
Yeah, I mean.
Do our homework.
Yeah, I mean,
We're all
We
prepared.
call Amy or
actually,
Dave if we have
just
questions.
just as sort of a preface.
I mean, can we just cut to the chase? I was mentioning this kind of just as a transitionary statement. I didn't mean to be insulting. I apologize.
Okay.
I was
Yeah,
just
I
getting
just
to
want
the
to move
point
it
where
forward.
I think one of the things that you could do that would make the analysis a little bit easier and more focused during the meeting is, as part of your preparation, consider drafting a potential motion.
How can we do that if we have a discussion? You can't make a motion before you have a discussion.
No.
Oh my
You can
gosh.
look at the application, consider the ordinances involved, and you want to outline what the issues are, and it will help you form a motion. Because it's hard to form a motion when you're sitting at the dais and you're trying to bring in a lot of new information. This is just a suggestion. I'm not here telling you what to do. You've been doing this for many, many years. I'm here just making suggestions, okay? So,
They're not really relevant, though.
I
I agree. I don't understand. I had to leave a job site. Everyone else had to leave their work to get here early. You're still on the clock. We're all working for free, and we came here so you could tell us that the ordinances are really not helping you in when you're defending the city. I get that. But that's
What-
something you should have told the city commission, and now you're telling us that we should be prepared, but you just mean it in that way. And then you have made two derogatory statements with because you're really sordid and you're not very focused when you're in here. It would really be helpful if you could become more focused, if you would prepare your motion ahead of time, which is absolutely contrary to all open meeting laws in the state. And Again,
Let me,
It's not
Just
contrary to
insulting.
open meetings at
wait
all.
a second,
I
time out,
don't mean to
guys.
be insulting.
Wait a second, time out. I'm the chair here, okay? So.
You got a gavel, hit it.
So let me propose this. So, it's walking in, and you don't know us as a group, but just to get sort of situated, it's fair to say that everyone that has been at this dais has been doing it for several years. And actually, anyone that's on this commission, who's joined this commission over the years, whenever they join the commission, one of the first things I do is actually, I call Amy and I say, Amy, who is this person? I'd like to call them and introduce them to the planning commission and explain to them what we ought to do. And I make those calls every time someone, at least when I know, there have been a couple people that have showed up that I didn't know were gonna be here. But generally, I mean, people know what the expectation is. And I think maybe just moving past that, and just letting Mark explain.
You know, I have a question, Mr. Chair. I think the first part was just, I think Mark was just trying to say, when you make decisions based upon the ordinance, but the master plan is all part of the ordinance, and when you make decisions to add more trees, it is all tied in together. I think that's all he was trying to say. And the next thing, only thing I think he's trying to say is that prepare and go to the site. I mean, everybody does that. We all go to the site. And I'm sure the next thing he'll say is there should be no ex parte communications. There should be no discussions with the neighbors. There should be no discussions with you know, the home community, or you know, all those things are. I think that's all he's trying to do.
Yeah, so, and I'm just trying to bring it
Thank you.
down,
Thank you.
okay? And so, but to summarize those points, I was just trying to, I guess, you know, sort of intertwine the master plan into the ordinance.
Yeah.
And I get this stuff as well as probably most people sitting in this room. So they're all important. And as far as preparing, I think everyone's been there. I would say, since we just talked about it, and I've said this to you personally, I'm not comfortable with preparing a motion on a matter that would come, that we don't know much about. So I would actually, to my commissioners, I would say that it's important to review the materials. And anyone that's ever watched me in a meeting has seen my stuff has got red marks and all sorts of information on it. So we're all preparing. But in order for me to come to a conclusion, I think it's important that we listen to our planners, our engineers, so that we understand the issue, listen to the applicant, listen to anyone in the audience that may have information. And after I gather all that information, I've been in many planning commission meetings that are really complicated, where you've got lots of complicated stuff. Our motions aren't all that terribly complicated, but I think we should, personally, I wouldn't encourage people to draw conclusions, and I don't know how you could prepare a motion without really knowing what side of the fence you're gonna fall on, so.
Or you could write one on both sides, you know, based on.
Yeah, I guess, but,
But,
Excuse me, Walter, if I could interject, you know, there was training given by Dirk to the planning commission when I was on the commission a year and a half ago or so, and I reviewed all that material for this training session, and there were actually, I mean, it was the zoning board and the planning commission, and there were sample motions in there. Some were for the zoning board, but there were some for the planning commission for for specific matters, but it's just, I think there's a format, you know, that where you fill in the blanks, you know, just so you're saying it the right way, and you're including, you know, a reference to whatever law you're citing, whatever law you're relying upon. So I don't think that what Mark is saying, you write out everything, because obviously you're gonna change your mind when you hear everything, but I don't think it would be detrimental to just use a form. You know, the zoning board, they do draft the motions, the one for and one against, and they use those. You know, the lawyer before each meeting gives the zoning board members the actual motion language. Here's one for approving, here's one for rejecting or not approving it, and people are free to add in or delete, but it's just a tool to use to keep the motion language consistent and to make sure you're addressing all the things you should be. I think that's all what he was saying, and it's been in prior training materials that the Planning Commission has received, because I did receive that, and I did review that just the other night. It was just like 2024, I believe.
Mark,
Yeah.
do you have a chance to review the previous planning training materials that Dirk put together, so you could be
Yes,
consistent?
I've been through that.
So is there a framework for proposing a motion in here?
I can put one together. There's not one in there, no.
Okay, well, Dirk
What I
had put
provided
one.
for you,
Yeah,
what I provided for you was the bylaws and some of the more frequently referenced ordinances. I thought it would be helpful in
well,
keeping
if you'd
with
like us to
you.
propose a motion in advance, and if you would like us to be more formal, maybe whatever Dirk had in his previous training, if you would.
The whole point of this.
I'm not suggesting, and I agree with the chair that I think it's important to hear what the engineers and the neighbors
Right.
and get all of the information before you make a motion. But I respect that you could have the format of a motion in front of you, and that's helpful.
And if I could just, sorry.
Commissioner Urban.
Oh, I didn't see you.
Comment?
Please.
I'm not, excuse me, I'm not quite sure that, I'm Craig Arnold, by the way,
A commissioner, I'm
a
sorry.
commissioner of many years. The first point is, not all of us are attorneys. All of us are terribly interested in the city. We live here. We are vitally interested, and we do spend time, we do our research. One thing I'm not, in listening to the back and forth here, we may not be seeing the forest through the trees. Are you aware of the fact that when some of us make motions, historically, we seek guidance from city council? We come to you, as you said at this table, and you help us craft the language. And part of your duty and responsibility is to guide those of us that may not be familiar with the courts to properly form the motion. And I don't know that you are aware of that, but in many instances, if you go back through the last 24 months of things that we've been looking at, we go to city council, city attorney, and we ask for assistance in crafting the motion, and the motion is crafted. And I suspect it's probably to create a position that would be defensible at issue, at litigation. Don't know, but I just thought I would throw that out.
And I appreciate that.
Okay, so it's consistent what we do.
Yes.
We don't sit here and we try to be clever and come up with these motions. We seek your guidance. We know that you're a skilled litigator and a clever lad, and we look to you for that guidance, because we don't know on a good day how to put the words together necessarily. We do know what the spirit of the city is, and that's what I want to bring us back to. We discharge our duties and responsibilities on the basis not of all the fine print, it seems to me, but the spirit of what it is that we are doing with this community. Just thought I'd share that with you.
And I appreciate that, and that's breaking my own rule. Going back to the last meeting, that's what I attempted to do on one of the motions, understand what the motion was, but also it helpful to have supporting factual basis for it and to tie it to one of the points in the regulation. So I do recognize that's one of the duties of the city attorney, and I attempt to do that. And I think, hopeful anyway, as we get more comfortable with each other, we'll develop that into a stronger relationship. But I do recognize that is one of the duties of the
I think
city
that,
attorney.
and I'm pleased to hear that, and I welcome that, quite frankly, as a longtime commissioner. We're here together with you and everybody, and the folks that we look to are experts. We're not experts, but we are here to work together. And I missed last meeting. I read the minutes. It looked like a very lively session. Seems to me, let me ask you a personal question. Did you go away with a migraine headache?
Been through worse. No, it wasn't that bad.
Thank you.
Part of the difference is, I think, the zoning board is different than the planning commission.
Yes, it is.
And I would like you to recognize
Yes,
the
it is.
different bodies. And we really, I completely agree with all of the commissioners and Craig Arnold, but I think at the last meeting, you were looking for us you were asking us to prove why and verbalize from an ordinance perspective why we were tabling that one issue. And we need you to help us tie the ordinance to our decisions and not expect us to say, because of Article 3-2, blah, blah, blah. We really rely on you as the lawyer, as Craig had said. And we also rely on the master plan. And are you suggesting that we cannot rely on the master plan
What I'm
to base our
suggesting,
decisions?
what I'm suggesting is you apply the regulation contained in the zoning ordinance in making your determination.
We
That's
want the
standard.
applicant to comply with the master plan. And are you suggesting that is not enough to support our decision?
What I'm suggesting is the master plan is kind of the goal that everybody's looking toward, but it's not the regulation.
But if their
And if the-
project conflicts with the master plan,
That's a
you
problem.
don't consider that reason enough to ask them to not have a cut and fill of 10 feet.
I don't
I-
know that
I
I would
don't
say
believe-
that during this meeting.
Should they codify it?
Sorry,
So,
I just,
well, I don't know that you'd want to come to that.
you're right.
I
I'm
don't
sorry.
believe that's the right conclusion. And I don't want to say that in a public meeting, that our master plan, I think we're past the master plan. I guess I'd like to step past that, because we could discuss this at length. We were talking about motions. I think there's, to summarize the motion discussion, what we've got is there's a suggestion that maybe you develop a motion before you walk in the door. We can all look at that in a different light. I expressed my personal view. Certainly,
And if I could finish-
excuse me.
if I could finish
if-
thought.
Right,
Okay.
if I could just finish my thought, I've listened to everyone, just trying to summarize this. So what we said was that there's different perspectives. We should be prepared when we walk in the door. I know personally, our motions here are not nearly as complicated as they are. I mean, usually we're talking about pool houses and whether or not there's trees. We're not talking about, in other environments I'm accustomed to, talking about PUD developments, zoning ordinances, whether or not a shopping center should go in. We're not talking about those really complicated things. So we should gauge what it is that's in front of us in develop. Most of our motions are, I approve this because it fits the circumstances. To Commissioner Arnold's point, normally what happens is someone will make a motion to approve something. rarely do we, I can't think of the last time we denied something. And usually, oftentimes it may be conditioned on something, might be conditioned on ZBA approval. And sometimes someone will make the motion and Dirk, in real polite fashion, will say, hey, you know, don't forget about, you need to get this conditioned on ZBA approval. Or someone might offer during the discussion that someone needed to be cognizant of some added landscape or something, and someone will say, oh, but let's make sure that we add that in. So it's sort of a collaborative approach, and it's worked well over the years, because usually, I can't really, like I said, think of a circumstance where we've denied something, and so it's a collaborative approach, and we look to council if we've missed something to offer that. One other thing I'd like to point out, to Commissioner, to Alice's point, ZBA is a different animal than the Planning Commission. There's 4 criteria that, I know. So it's sort of a different animal. I mean, those are, it's like an up or down.
What are the 4 criteria? I'm sorry.
But I'm just saying that there could be a form, just form language.
Yeah,
You know what I'm
so-
saying? Just to jog your memory.
Yeah, sure. I just want to distinguish, there's,
I know they're different,
Okay.
but there was a motion, there was a sample motion in the training materials
I-
that Dirk provided
No.
at the last
That's what you
session
said.
were one of yours, for one of the planning commissions.
Sure.
It was a specific one, I think it was for site plan approval perhaps, but I'm just saying, it may be easier if you got a form that you just fill in the blanks, not that it's written for you what you're going to say.
She's
You're gonna
repeating
obviously
herself.
base your decision on
Got
what
it.
you're seeing at the meeting.
yeah.
But that's all I'm saying.
Alice,
It's nothing new. What he just said is nothing that Dirk hasn't already said to
Sure.
the planning commission multiple times at multiple past.
I was just trying to.
Oh, I disagree. I think what Mark is suggesting is that we come with a full written, like the
I don't
zoning.
think that's what he said.
If I could clarify what I said,
Sure.
the point I was getting at is in reviewing, develop a motion, not necessarily the final motion you're going to give, but start developing a motion, because it will help you to look at what the issues are in the ordinance and give you a frame of reference. Because, and you should be doing that each on your own, not in collaboration with each other, because that runs a risk of violating the Open Meetings Act. And the whole point of this is so that when you gather together as the commission, you've got different viewpoints that are going to be discussed, and it leads to a better decision. So I'm not saying develop a motion to decide the case. I'm not saying develop the motion as the final ultimate decision you're going to make, and you're deciding this beforehand. But put together at least some thoughts toward what a motion might look like in order to hone in on what the issues you see are. And then I was going to follow that up with, after you have your motion, you may want to jot down some questions that you have based upon the materials that
Do
were
all that.
presented.
Oh my God.
You know,
It's just ridiculous.
This is a
So-
suggestion.
We've all
Hey,
had a
let-
lot
let
of
me- let me-
experience on
let- let me-
motions.
You know what,
Let me propose this.
Why don't I just forget all this and move on?
Let's just,
Yeah, let's move on.
I'd like to know what the Open Meetings Act is. You're the city attorney.
hey,
What's the Open Meetings Act for people who are lay people on here? How are you interpreting the Open Meetings Act that we are not allowed to
can I
talk?
suggest this?
Because he's a city attorney, and
So
I would
I
like to
wanna
know his
suggest this.
interpretation of that.
I want to suggest this. I think it's important that we sort of stay on track. So I'm going to propose, Mark, why don't you carry into your next subject?
Well, I was going to talk then about the planning functions, and I think I touched on that earlier, the short-term planning and the long-term planning. The planning functions of the Planning Commission deal with proposing the short-term, deal with proposing amendments to the existing ordinance, and based upon either comments received from the City Commission, comments from the City Attorney, perhaps input from the ZBA, perhaps input that you receive from public comment at your Planning Commission meeting. Listen to that, and if you see something that, you know, maybe the ordinance needs to be tweaked, that's something you want to start a process on and reviewing. That's the function of the Planning Commission. The other aspect is a little bit more formal, and it's the long-term planning function, and that's more developing the master plan. You're required to review the master plan every 5 years.
Which
But
we
that's-
do, we do that.
But that's what you're supposed to do. You can review the master plan anytime you want to if you feel a need to, so. And you're all familiar with that
And
process.
everyone knows we
So-
just got that done.
We
We just
just
got
finished
done. So, we're good for,
5 years.
At least 5 years, yeah.
well, I think 4 at this, well, I don't know. I think we did that in September or
I
something.
probably won't be alive in 5 years.
Well, I think one point to the master plan is I've been around, well, I've been around for 3 or 4 of them. And it doesn't change that much. I mean, we don't have a big city center. We're you know, so it's easier for us, and we've held true to what George Booth wanted in 1932 when he adopted the master plan for the city of what they were looking for. So there hasn't been many changes to it. So most people understand, I mean, I would say not most, all of us know that master plan inside and out.
Yeah, and that's the nature of this community.
Yeah.
It's got a very stable master plan,
Yeah.
and so that's not really probably the primary focus of the Planning Commission because things are relatively stable.
Right.
But in implementing the ideas in the master plan, I think you're more focused on more the short-term planning concerns of making sure your zoning ordinance is reflecting the intent of the master plan, and if its shortcomings are pointed out, that's something to consider. I'll take a little out of order here. There was a question regarding the Open Meetings Act and what I interpret that. There's things you can do, and there's things I'm going to recommend you don't do. Because the Open Meetings Act it's possible to violate the Open Meetings Act without even knowing it, and that's a concern. All it takes is somebody hitting reply all on an email, and all of a sudden you're in danger of being cited for an Open Meetings Act violation. It's something to keep in mind. And again, I'm saying, yes, you can exchange emails individually one to another. That does not violate the Open Meetings Act. I'm also encouraging you not to do that because it's a risk. And again, it's going to happen. There's going to be instances where you're going to do it, and it's not a hard and fast rule.
On which topic? You just said that maybe we should be working on finding holes in the ordinances, and hey, we could improve ordinances. What do
I'm
you
gonna
think
cover
about that? When you just said now
Yeah.
what we can, are you including that?
That's what I'm going to cover.
Okay.
The other
Covered.
The other part of the Open Meetings Act, and the reason why I'm encouraging you not to exchange emails outside of an open meeting, is because you are a commission. And I go back to the opening. The design of this commission is the exchange of ideas amongst all the members. And so if there is an idea where, hey, we may need an amendment or consider an amendment to the zoning ordinance, that's something that you would want to bring to the city clerk and maybe consider adding it to an agenda and have a discussion about it. but do it in an open meeting. Because what you do as a planning commission is supposed to take place in an open meeting. It's not supposed to be in some committee, you know, it's not supposed to be in a series of emails. It's supposed to be in an open meeting. And to the extent that there may be some need for additional study, yes, you can send it to a committee made up of individuals, but that committee meeting needs to be an open meeting as well, because you're doing planning commission business. Whether you reach a final decision or not, you're honing in on decisions that the planning commission is ultimately going to make. And if you're at all affecting that decision, it needs to be done in an open meeting. And that is also a requirement of your bylaws and the city ordinance code. What you're doing, the business, is supposed to be in an open meeting. So yes, it's not a strict prohibition against emailing one another outside of an open meeting. I'm encouraging you not to do that for the reasons I just explained. I think it's also important to bear in mind that in addition to emailing opens up potential for Open Meetings Act issues, anything that is in writing, including an email, is going to be subject to FOIA as well. So bear that in mind. So for a number of reasons, FOIA, Open Meetings Act, and just for the basic concept of the function of the commission, I would encourage you not to have email conversations outside of the open meetings. And then a little out of order here, sorry about that. I did want to touch briefly on Robert's Rules of Order and the application for your meetings of the Planning Commission. In general, Robert's Rules of Order are very, very cumbersome, somewhat antiquated, formalistic, doesn't work well in a small commission such as the Planning Commission here. But there's some principles to take away from it. There's principles about waiting until you're recognized to speak. And this assists in a number of different ways. One, if somebody is speaking, you should be paying attention to what they're saying, because that's part of the function of having the commission in the first place, is you're supposed to be drawing from each other's thoughts in order to reach a firm conclusion. Practically, it's important because there's somebody here that's taking minutes, and it gets to be very complicated if there's a lot of different conversations going on.
She
Now-
handles it beautifully. She's our treasure.
So,
And-
since this is being recorded, and it's for the record, public meeting and all, there is 4921, there's a procedure in small boards in Robert's Rules that say members may raise a hand instead of standing when seeking to obtain the floor. Motions need not be seconded. There's no limit to number of times a member can speak to a debatable question. Informal discussion of a subject is permitted while no motion is pending. When a proposal is perfectly clear to all present, a vote can be taken without a motions having been introduced. Unless agreed to by unanimous consent, however, all proposed actions must be approved by vote under the same rules as in larger meetings. The chairman need not rise while putting questions to a vote, and if the chairman is a member, he may, without leaving the chair, speak in informal discussions and in debate. And there is a difference under Robert's rules with regard to a small board and a large assembly. So which one are you referring to? Do you want us to all of a sudden color what these people have been doing for 10 years to be something different? Because why? Why are you coming in here to talk to them about doing something different than they've been doing by the rules in a small board this whole time? I had to look it up. They have been doing it. They have been following the rules. So why are you coming and having them do something different?
I wasn't recommending anything.
You're here giving us and telling us about the importance of Robert's rules. So what is the impetus since we've been to one meeting? Who's having you come and tell this board that they should do something different that they've been doing, and they've been following Robert's rules for a small board? Where does this come from?
What am I telling you to do differently?
Where does this come from? Why are we having a meeting on a night that we could all have stated our jobs because there's nothing on the agenda? So something you could have done in the first 10 minutes before our July meeting, and now you want to talk to us about Robert's rules? And you do know the distinction between a small board and a large assembly?
Yes,
Okay.
I do.
And they've been following the rules of the small board this entire time?
The reason that I mentioned Robert's rules in general is because in Robert's rules for application for large groups and frankly for small groups if they choose to, the basic premise of Robert's rules is that in the large group, the chair does not participate in any of the conversation. He doesn't vote, doesn't make a motion. I'm not saying.
And we're
to
not
do
a
that.
large assembly, right?
I'm not saying to do that.
Okay, you're not
What
saying
I'm-
that today to do that,
What-
okay?
I'm what?
You're not saying that you're bringing up Robert's rules and telling this board that they should follow Robert's rules when they have been following Robert's rules.
Excuse me, if I may say something, the bylaws of the planning commission, your bylaws say that Robert's rules apply to your meetings.
Commissioner, I'm well aware I've read the bylaws and they do say that, but there is, in Robert's rules, there is a different rules with regard to small assemblies and large assemblies.
But he's just addressing Robert's rules in general. I would let.
Yeah.
why don't you
So
just-
let me.
Can I finish? Can I finish, please? Because the point I was making, the only point I was making is that you're all commissioners. You're all commissioners. The chair doesn't have any special authority, and his authority is not limited. The only role he has as a chair is to organize the meeting, keep it moving, on topic, announce the different agendas as we go through it. He's to moderate the meeting. Okay? That's all I'm saying.
So in my role as chair here, so what I'm gonna suggest is, so we've summarized, that Robert's rules, it's in our bylaws. I think, everyone's clear on that. And so moving forward, the provisions, Robert's rules is really a broad set of rules. I've seen just, it'll work for groups as small as 3 or 4 people or as big as 50 or 100 people. So in our situation, we're not gonna follow the more formal guidelines, which don't fit our organization because we've only got 9 people, and it's better that we do this in the fashion that we do. If anyone's ever gone through that whole process, that formal process is go through, gather information, make motions, have further discussion, and then have formal votes. We don't do that, and having sat through many meetings in many communities, and I know the planners sit through a lot, and I know the communities you sit in because I do business in some of those, and they're not a whole lot different. There's ranges that there's a wide variety. I just read one of your memos for Sterling Heights. I saw what you did. I go there a lot. So they're a more formal process. I don't know if you've ever sat through one of their meetings.
Yes, we just finished our master plan.
Okay, I read part of it. But that's a more formal process. Their population is nearly 40 times what our population is. And so they've got, you know, lots of different things. So that works there. In our process, we're following the tailored version.
Sure.
This-
I'm not proposing any change.
Okay,
It's in your bylaws.
okay,
As part of the training, I thought I should cover it.
okay, that's fine.
That's all.
I'm happy to hear that. That's not what I understood when we discussed this. Yes.
And I'm not sure if this follows Robert's rules, but I'm going to interject here. I came here today to learn some things, and I think Mr. Roberts was about to talk about some takeaways that we could all use and apply to our smaller format of meetings. I don't think he's suggesting that we try to follow Robert's rules to the T. I think he's suggesting that there are some takeaways that we might want to consider, and I thought he was just about to say that, at which point it blew up into something.
Okay, I was just trying to summarize and bring it
I'd like to
forward.
hear what the man has to say.
If I could summarize.
Go ahead, please.
Okay. The reason I brought up the big rule, the formal rule, is that's kind of the principle applied in Robert's Rules of Order. For smaller groups like this, it's unworkable in that formalistic style. However, the principles should still be recognized. The principle that there shouldn't be sidebar discussions, and that's not a hard and fast rule. There's going to be sidebar discussions, but the rule says it shouldn't be disruptive. And I would emphasize part of the reason we're doing Robert's Rules of Order is because it is in your bylaws, as I said, but also the nature of this commission. You've got people in the audience on your typical, the more quasi-judicial function of the Planning Commission. You've got people in the audience that may be neighbors that want to comment on a development going on next door. You've got applicants before you. You may have professionals here. And just appearance-wise, it looks a little suspect when there's a couple commissioners talking over here, a couple commissioners talking over there, while somebody else is talking. I think adherence to Robert's Rules of Order, in addition to being in your bylaws, I think they're there to reinforce the credibility of the body as it's to reinforce the credibility of the body making a firm decision. And I recognize Robert's Rules of Order for smaller groups is modified. I recognize that. I'm not asking you to change that. What I am suggesting is you adhere to the principles of Robert's Rules of Order, where the chair is the moderator of the discussion, where everybody participates one at a time, and avoiding sidebar conversations as much as possible, because again, when you've got an audience, it can be a little, it doesn't look good when you're making a decision on some property and there's people having different discussions in different areas. So again, I recognize that's not a hard and fast rule, but the rule is that if you're gonna have sidebar, it not be disruptive, and you run the risk of being disruptive on the function of the planning commission as the decider. Is there something?
No, because I did read it into the record, that in the Roberts rules, and I thought it was important that I print out the law since we didn't get any paperwork prior to this. It says informal discussion of a subject is permitted while no motion is pending. 7, that's 4, under 49.21. And number 7, under this same procedure in small boards, is if the chairman is a member, he may, without leaving the chair, speak in informal discussions and in debate and vote on all questions.
I'm not saying anything different.
You,
I'm talking about sidebars. I said the chair should be more the moderator, and I think he should be, consistent with the overarching principle of Robert's Rules of Order, where the chair doesn't talk at all. But that's not practical in a board this size, and frankly, it's not consistent with Robert's Rules of Order for the smaller group. I understand that. And when I'm talking about informal discussions, what that's referencing is a discussion before a motion is made into developing the problem, into developing a discussion on a topic. When I'm talking about sidebars, I'm talking about people having a private conversation on the dais while somebody else is talking. That's a sidebar. It's not prohibited, it's discouraged, but it's not prohibited. But what I'm suggesting is, although you can do it, you should avoid it if possible. And certainly if it's going to be done, it needs to be done in a non-disruptive way, which is in the rules. That was the only point I was making.
Are you about ready to go on to your next subject?
I really don't have much else to cover.
Let me then I'd like to summarize because there's a broad, what I was talking about is this broad range. And what I'd like to explain is what, as chair right now, what my expectation is. Because right now, I'm running the meetings, and our procedures have been the same, more or less, for the 17 years that I've been on this commission. And I didn't set the standard for what we do. Actually, Bill Hampton did a lot of that. But those procedures were in place for many years. So we're at the middle range. So I can almost recite what you're speaking about, Catherine. And under the small committee rules, there's no requirement for a second motion or for a second on the motion. People are free to have interactions during the meeting.
No limit on the number of times anybody can talk on a subject.
Right.
I'm familiar with
So,
it. Yep.
no, I know you are, but I just want to summarize what my expectations are. Because right now, I'm sitting here, and so my expectations are, we're in the middle. We do go through when a motion, so our process is, and I don't expect to change it, is exactly as I describe it at the beginning of every meeting, which is we look to our planners, we look to our engineers for their input on an application, we look to our applicant, we look to the neighbors that may be in the audience, we collect all that information. Hopefully, we do that in as organized a fashion as possible. Everyone needs to be, I try when I'm sitting in this chair to call on people. Sometimes, I'm gonna call you Commissioner Hendrickson instead of City Manager Hendrickson. Sometimes he's in the corner and he's trying to get my attention, and I may not be as responsive because someone else is talking, but I try my best to acknowledge people. Sometimes people interject. People have asked me to, well, collect all the thoughts, let the planners speak and the engineers speak, and sometimes that works, sometimes it doesn't. Sometimes there's commissioners that will ask questions, and my MO is not to cut people off. I can cut people off, sort of. I've tried here today. You know, sometimes it works, sometimes it doesn't. But I respect everyone sitting at this dais. I know everyone has spent a lot of time when they come to these meetings and they're all prepared. And if there's something on the board and someone has a quick question, you know, sometimes it almost makes sense to let them ask the question. If it's something that involves grading and a planning item, it's best, you know, to let it move forward. But, yeah, we should be, as we're talking through these things, be respectful of each other, and I think we are. As much as possible, I guess, let's make sure that we're all, I guess, talking one at a time. That's, but under the rules, actually, you can have a free conversation. And I'm suggesting, as I'm sitting here, I don't think we should have a free conversation. We should have an interactive conversation, so we're building on what each other think about an application. I've taken the position always that I'm part of the discussion. I've never stepped back from that. And under the rules, I'm entitled to do that. I always try to be the arbiter, though. I sit back and I wait until the end to make my comments. And I expect, while the rules permit you don't have to have a second, that we do that. That's our policy, that we make a motion, we have a second. We look to our city attorney as we're crafting that motion to, at the end, if we're missing something, to offer your opinion and help us craft that. That's sort of our practice. So it's not on the most relaxed end of the spectrum. It's not on the most stringent part. We're in the middle, and I think that's where we've fallen, and that's where we will continue to move forward. Yes, sir.
I just have questions. There's things I didn't hear that I want to just understand from my perspective. So my only concerns are really have to do with motions and enforcement of the ordinances. So when, I don't know if you have any suggestions, but for us, for the administration, we just want to make sure that we have a real clear motion so that we can provide a direction to the residents. Like, say if you're going to table it, that we have what the city commission, or what the planning commission recommends or would like to see. It would be helpful if that was tied to an ordinance, because we do have questions at times where, okay, where is this requirement in the ordinance? And there's many times I can do that, but there are times it's difficult for us. So we just want to provide the expectation and the direction. And then I'd like to have some sort of opportunity to, as part of, when a motion's happening, if there's any, sometimes I raise my hand to try to get my point in, because I can see how it might be troublesome or difficult for us to enforce or to enforce the ordinance in particular, or to provide the proper guidance. So I don't know if, Mark, you have any recommendations with that, but that's a concern for me when there's a lot of discussion and it's not done, and by each person talking and listening, because I can't sometimes get what I need from the administrative standpoint, just to provide a direction to the residents. And we're left with the residents asking us, hey, I didn't understand what was going on. There was a lot of discussion. I know it's all on the record. But at the end of the day, I think the motion is what we rely on. That's what we rely on, because everybody has different opinions. We can go back and look at the record, but we rely on the motion. And so, I just want to make, I don't know if you have any recommendations with that, but
I
that would
do.
be something I would be asking, just to help us out with. And it doesn't always happen, but there are times where, it's just, you know, the discussions and the motions even all over the place, so.
Well, before our city attorney jumps in, can I just remark to that?
Yeah,
Your office has already established a pretty high bar of competence. And so what I would want is if there's anything that was set up here at any particular topic and agenda that you didn't understand or need to clear, that you stop them and you asked us, what is it that you're really saying? Because for the most part, we kind of presume that you understand and you get it. And if there's a motion that's inarticulate or somehow goes off the rails from the ordinance that you think you can't explain that to the applicant if it's tabled or if it's not otherwise obvious, then you need to help us with requesting clarification, because otherwise you guys do such a great job in distilling all of this, both from administering it and then reporting on the minutes, that you know, we're going to presume you get it unless you asked us to stop and
Right.
restate it. So
well, I greatly appreciate that, because there are times when we'll have a lot of applications going on, and I have to go back to the record. I have to look at the motion. Our process is, and I will go out to the sites, and I'll bring the motion with me, and I'll talk to folks at the site. And if the motion's not clear, you know, I can't, I mean, I usually get the job done. I say, well, I think you need to do this. I think you need add some more trees. But I'm just thinking from our own protection and making sure that the ordinances are followed, and making sure that the expectation is followed. If I could have that opportunity, that would be great. So I don't know, there's a motion, it's seconded, and sometimes if there's discussion after that, just between the commissioners, that may be the opportunity. I don't know if that necessarily has to happen.
well, that may be part of the confusion, if there's a motion and then subsequent discussion and dialogue that the applicant's hearing and is getting tangled up on, well, what are they really saying?
Right.
And that's a fair, wait a minute, let's back up and reestablish what was really voted on. But you need to help us clarify the record, and because obviously the applicant's hearing all this, the representatives are hearing what was discussed, you guys are hearing what's discussed, and if understanding what you typically need to hear to assist the applicant in processing what was done here, if that's not helpful to you, then you need to stop us. And
I like hearing from both you and Amy a lot during the thing, because you are the ones who are the contact. I also like to be able to ask questions of the city attorney, and we do a lot, and we did with Dirk a lot. And we didn't, but he did it in kind of a way that said, this is what the law is, and he helped us without saying, this is how I would say it because the residents are in there. So I don't know, all the time, as Commissioner Arnold said, we are going to ask you questions. We are going to ask you, excuse me, city attorney, what is the particular law? Because we really need your help on that. And if almost on every single time that we're, not so much when we're tabling something, because usually that's because they're not ready, because you know, they're not close to being ready. But if we're turning something down, we do not do it without having the input of the city attorney to say, what basis? Oh, could we turn it down on this basis? You're like, yes, you could turn it down on that basis. And that is an open thing that we do in front of the resident so that they are really clear on that. But when we're tabling something, the city manager has to be seriously clear on that. And it's not in an ordinance. This is what they're kind of asking you right now, because they really want to allow you to build. We really want people to build and be happy in the city. We rarely have to turn someone down. We want to do it on a legal precedent, and only that. Not so much tabling, but we don't want to turn someone down just because it's, you're next to a waterway, and then we'll ask you, how should we say that in the motion? But we do that, as Commissioner Arnold said, all the time. And we
Can I interject? I think Will makes a good point. So if I'm sitting here, I always try to acknowledge you. If I miss, no different than when Dirk was sitting in that chair, he was assertive enough to say, hey, you know.
I just don't want to be rude, because even right now, I have
That's-
questions, but there's this free flow of conversation, and that's difficult in these public
But,
meetings.
you know.
You're a member of the commission.
Yeah.
Yeah.
So why would you not,
So-
you have every right to ask and talk.
Why-
So maybe can our takeaway be
Yeah.
is?
But I can do that, I just
Yeah.
don't want, I don't want to
I
be
like
seen as
it.
being rude.
Yeah, I
No, we
mean,
want you to.
you're a member of the commission, so no different than if Susan's saying something or Lauren is.
And we want to hear, we want to hear what
sometimes,
you're going to say.
with all due
Could be
respect,
important.
they don't ask. They just, barge it. No, I'm just
I'm,
kidding.
yeah,
Okay, I'll
But,
raise my hand now.
so, yes,
I'm just trying to be, yeah.
Is it okay?
Brad, please.
Okay.
This is exactly one of the things I was hoping to come away with today, because I've been on planning commission previously and as a new member, really unsure about when it's okay to speak up and say something, because sometimes, you know, the timing of what you say is important, because if
Yeah.
you're on a particular issue, and if you let it go too long and bring it up later when there's a quiet moment, it's already gone, and, you know, it's just too late. So what, and this is maybe a question for the city attorney as well, is, you know, what is the process for somebody new, or just anybody, if you have a point to make on planning commission, and there's a lot of conversation, I mean, what is the process that makes it a little bit more organized, so that everybody, if they have a point, they can have their say, but the trickier, complicated part of that is when there's a timing issue, and you need to make a point at a certain point in the meeting, so that it's recognized as applicable to something being discussed at that time. How do you interject?
Well, let me answer
Because
that.
I get kind of uncomfortable, and I was uncomfortable in a lot of those meetings where I saw something that maybe other folks weren't recognizing, and I wanted to point it out at the time, because that's when it was important to point it out, but I felt like I didn't really, I didn't feel like it was okay to interject, because there were other people speaking, and so what is the process?
Speak up.
I guess.
Speak up.
Being more assertive?
Speak up.
Let me address that, because I'm the guy that has to make that acknowledgement. And so I think I explain what I do, and some of it's an expectation of the commissioners. So we shouldn't be talking over each other, right? So to your point, you just mentioned, Brad, well, geez, I'm not sure if I felt comfortable interjecting at that point, because other people were speaking. Hopefully, only one person is speaking at a time, and I think everyone's generally respects that. If the proper way to do it is just as you just did it, just, give a nod, or Dave, I can see Dave usually, it's simple, he's right across the way. When Craig was looking for my attention here about 30 minutes ago and wanted to offer his comment, I think Connie sort of nudged me. So, I may not see someone, so I think everyone needs to be, I guess, no different than Will said to Dave, make sure you put yourself out there, because I may not see someone who's got a comment.
Sure, I understand how to survive in a meeting, it's just that I'm wondering in the context of Robert's rules, and I was hoping to get some clarity on
Yeah,
that.
that's what I want, clarity
How
on
does
that.
how does that apply to that kind of situation? That was really my question. Yeah, I get it, be more assertive, do something so you get noticed, but beyond that, is there a process that we should maybe keep in mind? That was really the question.
Well, I've been to other commission meetings in other states and other cities, and some that are in the larger 12-plus members, they go down, what would you like to say? What would you like to say? And they allow the entire presentation to be made before any of the commissioners speak. And I think that could help our flow of our meetings as well, because a lot of times we have a question about, is the cut and fill a problem with the drainage? But then we haven't heard the engineers say that they've done the French drains and, you know, the flow is okay. So that question goes away. But if I get it in my, you know, if in the early on part of the presentation, I can write that question down, and I would encourage all the commissioners, when they're making their presentation, if you have a question, and it may seem really urgent, I'm guilty of it too, of you have a question pop in your head, you can write it down, and then after the entire presentation, after the engineers, after the planners, after the applicant speaks, then we can all interject and ask our questions, and because a lot of our questions might be answered by the engineer or the.
I've actually changed my vote on the times that you have spoken and brought up things. So, I mean, I really depend on what you were bringing when you were sitting here on the planning commission. You said, how about this? I'm like, darn it, you know, that is nothing I had thought about before. And I really depend on listening to every one of these people when they're coming here and they're discussing and they're bringing up things.
I think
and
the
our
mayor's
new person is now
I think
talking.
the mayor's suggestion is an excellent suggestion.
Well, can I
Yeah,
just
that doesn't work.
pick up on what
Yeah.
you were saying, Catherine, but also what I thought I heard you say, Brad, that, you know, if there's a necessary sequence to raising a topic that may have already been addressed, and is it all right to revisit it? I think the answer is absolutely yes, because all of us think differently, and things come to mind at different times, and so regardless of when a particular topic is whether it's grading or landscaping, might have been arguably moved on in the context of the agenda. If something later occurs to anybody that's relevant to something that's already been discussed, absolutely raise it, because to Catherine's point, I mean, it may be something that we all want to think about that we didn't previously think about. So raising it out of order is, in my opinion, certainly not violative of Robert's rules, but I think it adds to a more robust analysis of the topic. So, I mean, if that's getting at any of your concerns, I mean, I don't think when you raise a topic in a particular matter matters.
That's why I think we can.
They're still
discipline. I'm
informal.
going to try and discipline myself during the presentation of all the professionals and the applicant to write my questions down.
Yeah.
Because it doesn't matter if it comes up later, we can refer back.
That's an excellent suggestion. That would be very helpful, because then everybody can listen, can hear each other with all their questions, and everybody have a chance to speak. I don't know if it's I think it's worth trying just to recognize people and let them talk, and then that person's done, you can recognize the next person. I don't think it's a bad thing to try. I know that I can't necessarily, I know there's been many a times that I've tried to be polite and raise my hand, and I've not been recognized, and the issue has moved on. I figure it out, you know, I'm not too upset over it, but I always think that there's gotta be a little bit better way that we can all just interject. That's my only point.
As far as Lauren's suggestion about waiting until the end, I've actually, in our last couple of meetings, I started the presentations out asking people to do that, and so, but we violate it. And so I just want you to know,
But at least try. And,
okay, and I'm game. I just want you to know, I hear you. I've actually offered that we do that, but I'm not one to slap people's wrist if they don't follow. So I think the fact that we're just sitting here and discussing it, and we're all sort of cognizant of that, and we're thinking about it, maybe we'll do a better job of it. And so I think that's a good suggestion. Actually, we did that during COVID, if you remember. When everyone was over the phone, what I said, because I'd be sitting in my office with all my stuff sitting on a conference room table, and I couldn't always hear different voices and so I said to everyone, please hold your questions until we've heard from both the planner and the city engineer. and it worked out fine.
It
And-
did.
And it's
Make a
easy to,
recommendation with the agenda and all that, maybe, you know, and we don't have to change the agenda, but I'm just thinking, you do a great job in the beginning of the meeting, just kind of laying it out how it works. But maybe you could say during that process, we're gonna talk to the professionals, we're gonna do this, we're gonna do that. We're gonna talk to the applicant, and then I'm gonna listen to the audience or any public comment. And then we'll discuss it up here as a commission. And if, to the mayor's point, if we write all your questions down, I think it would be, that would help the whole situation, I think.
so does everyone, just sorting through this, does everyone believe that we should listen
Those are your points, I think.
to the professionals, listen to the planner and the engineer and ask questions then, or do you want to hold them until the very end? I mean, I know how I would vote on that, but
I just think a lot of our questions are answered after we get the full report from
I agree with
both
you.
of them. So a lot of those
I agree
questions
with
might
that,
be dispelled.
but would you
And
wait
simplify.
until after the applicant? Or would you propose, I think there's benefit actually in listening to the planner and the engineer, for sure. I think there's benefit in surfacing questions at that point, and then, so that the applicant understands what the questions are, and we can address them. Otherwise, you're gonna have almost too much. So, listen to the planner, listen to the engineer, formulate our questions, hold our questions. They'll have the benefit of whatever's on the board, ask questions, and be mindful that the applicant, then they can, which they often do, they defer to the applicant. They'll say, you know, you need to ask the applicant this. So we'll sort through it and get through it quicker. One thing I would also suggest is we're going through these. I try to be respectful of everyone's opinions, and sometimes we discuss things at length. I can remember one issue, and I'm not gonna bring up a street name or anything, but there was an issue with a fence, and, you know, there's differences of opinion, and with some of the people that are sitting in this room right now. And so at some points, we've got to just, we could sometimes talk about them for, you know, a lengthy period. Maybe come to grips with where is it we want to land on this? And, you know, just come to, I mean, we were discussing the height of a glass wall a couple months ago. And maybe just coming to a conclusion, because sometimes it doesn't matter a whole lot, right? So that's just a suggestion, because I think that would speed things up too. So,
I have a
yes.
question. I don't know. He answered my hand, Dave.
Yeah, I noticed it. I noticed it right away and I stopped talking. I wasn't talking anyway, but.
You know, I wasn't at the last meeting, so I don't know, but I've been on the commission for not quite as long as some people, Connie. But, you know, I think Commissioner Arley really summed it up about the spirit of the commission. The people who are on this commission and the people who work for the city and the planners and, you know, everybody wants to do the right thing. Mm-hmm. Everybody wants to do the right thing for the city. And so when we're all up here and we give opinions and suggestions and I agree, some people's suggestions, Brad, when we're on the city commission, will say something, I'm thinking, dang, I wish I would have thought about that. And, you know, it's just that everybody has their opinion. But I think, Mark, for you coming in, I would say on tabling, and I did watch the meeting, you know, who used to make us table more than anybody was our city attorney, Dirk. He would, a lot of times, when everything was going around, he would sit over there and say, can I make a suggestion? Can we table this? You know, I mean, how many of you guys have heard Dirk say that? He would say, can we table? Because he would see everybody just, it wasn't really going anywhere. And when we say we're looking for that, I can remember the very first motion I ever made on the planning commission, I was scared as heck that what I was saying was wrong. And I immediately looked at Dirk, I'm like, is that okay? Do I need to ask anything? You know, we look to that's what we are looking for from you. So I think we all appreciate you coming in here and giving your insights, because we're all been doing it for a long time. You're a fresh set of eyes. So is there room for improvement? Absolutely. But the only thing I'd ask to recognize is that we're all here because we love the city and we want to do the right thing. And if ordinance or something is not where it should be, then let's get it in front of the city commission and let's change it so that it does reflect the thing. That's what we need to have, instead of, well, the ordinance doesn't say that, so you can't do that. Well, we need to fix it then. So that's my 2 cents on. I think everybody who's in this room, I know how much work goes into all of these meetings, and to plan them, and to go over it, and to communicate to all of us what it is, and we all appreciate each other. So I think it's good. If there's room for improvement, that's great. And maybe now, Dave and Amy, we just look at you and say, you guys all good? You know, and so
Yeah,
if you guys understand and you're good, because if you're not, like Will said, you need to stop us and say, no, define this better for me. That's on you.
Can I make 2 points? One, on the motion to table. I think it's a valid thing to do if there's kind of an impasse. But in what I was getting at the last meeting, if you're gonna table it, give the applicant some direction on why you're tabling it, so that he can take some action to address that point, either by ignoring it, insisting on his own way, or maybe he'll go back and say, you know what, I could tweak this a little bit and come back with a better product. So that was the only point
I think Walt is
that was
very
making.
good about
Okay.
telling them, this is what we don't approve of, and you need to fix this, and you need to do, and you need this mix of trees, and you need, I think Walt is very good about summarizing that for them.
Okay, I did not hear any specific direction at the last meeting, which is why I made my comments. But the other thing on the point about when to make your comment, I think it's important, again, going back to Robert's rules, being respectful of everybody. When you're speaking, pay attention to others too. And if you see somebody that looks like they may have a comment to make or maybe gesturing, maybe pause for a minute and mention it to the chair, or
The elbow
you're
works.
the elbow works, yeah. But if the chair is like looking at me, I can see the mayor has her hand up, and I'm gonna indicate to the chair that, you know, I think there may be a comment over there. Everybody can do that. It's just part about being courteous, and again, the whole import of this is to hear from everybody participate. So if everybody comes into it, and jotting questions down is a great technique. The other point I wanted to make is, as the chair, if a comment or an issue is raised and it's something that has some merit to it, or it's a valid point that needs further discussion, but you're in the middle of a discussion, you can always say, you know what, issue was raised, let's wait until we finish this one, and then we'll come back to that and make a note of it, and then wrap up that discussion, and then go on to the next issue, just to keep the structure. So that's another technique that I'm sure you're aware of, but that's a technique. So, those are my points.
Good. Any,
I have a question, Mark. One thing that I heard, this is out of context, because it's something that came up at the beginning of your presentation, and it was about site visits. When they go on site visits, I heard someone say something to the effect that they go out and they do everything, and they talk to the neighbors, and they talk to the applicants, and they talk to the homeowners association.
Yeah, and I was trying to make some points on that. It is important that comments be presented to the entire commission. And if you go out to a property, which I encourage you do, not necessarily to make your own assessment, but when you're reviewing reports, it's always kind of nice to have your own personal reference points. And, you know, there's a lot of ways you can do that besides visiting the site. But if you're going to do a site visit and somebody approaches you, I think the appropriate thing to do is, let me stop you right there. I'm one commissioner. I don't make the decision. And I think your information, if you want to have some impact on the decision, should be presented at the commission meeting. And I would encourage you to attend. If you can't attend, you can always put it in writing and send it in. But I would avoid the one-on-one interaction with people because, one, it gives them the wrong idea that now all of a sudden their point has been presented to the commission because it hasn't. And two, the point was made earlier about pre-deciding things. You want to make sure that you have all the information. And so my point about reviewing the packet, jotting down your questions, some initial written questions about reports or potential issues that you want to raise, that's all stuff you want to bring to the commission meeting, and then avoid situations outside of the meeting where you're gathering information, because that really needs to be part of the record, either by somebody appearing here and speaking or by submission of a written document that will then become part of the record. So I think that addresses the issue. I don't know if anybody's got any other questions on that.
Any other questions or comments or?
Under Roberts, in the context of our group, what's your opinion on the chair making a motion? Because in the past, that's not something that we've done.
It's something that's allowed under Robert's Rules of Order for a small group. It doesn't have to be. It's my understanding that the tradition has been on this commission that the chair doesn't make the motion. I've got no problem with that. I think
Either way, the chair making the motion or not?
There's no preference. It's really how you conduct your meetings. Again, it's something that's permitted on a small group. It's not required. The Roberts Rules for small groups are not requirements. It's the ability to modify the more structured large group Roberts that's the point of the smaller group meeting, flexibility on the rules. For instance, for a smaller group meeting, you don't need a second on a motion. That's one of the things you can do. You don't have to, and you choose not to. I think it's a good practice to have support for a motion. One, it makes certain that there's support for the motion, but also it kind of triggers a different type of discussion. It's now a discussion on the motion that's been made, and there may be some issues with that. Because one of the things I think important in the motion is not only an accurate and thorough description of the action that needs to be taken, you know, whether to grant or deny, you know, whatever it may be, but also the factual basis for it. And I think that's almost more important than how you articulate the action is the factual basis for it, because that's what's going to be evaluated in determining whether to affirm or deny, affirm or reverse a decision. And the reason I raise that is that when a motion's being made, listen carefully to the motion and go back over your own notes or your own findings, your own recollections, and you may have a fact point that somebody else didn't think of that would assist in supporting that motion. And after that motion's made and seconded, you might want to raise your hand and offer that as kind of a friendly amendment. Indicate, hey, I think this was a valid point. Would you consider adding that to your motion? And the person can either do it or not. So I think, again, that's another reason for the commission structure having a more effective decision-making process, so.
I have a comment with, if you don't mind, with, as far as ex parte communications. One of the things that that we're concerned about from, just a due process standpoint is that, we're concerned about that because sometimes residents will come in and make comments about communications and that. And, what's your opinion on, you didn't really say this, but in my opinion, it's kind of a due process issue, because there has to be an impartial hearing, fair hearing, and let everybody have their conversation. All the planning commissioners have the conversation at the dais in the open meeting.
Well,
And so, that is,
yeah, it is, again, it's the due process, the formal term for it. What I was referring to as having all the comments being made before the entire commission so everybody can hear everything is kind of a more informal way of saying that. But yes, there are due process issues involved. There's also,
I don't want you to-
issues for the applicant.
Yeah. Yes.
That, he's got a right to respond to those comments, and if they're just made to one commissioner, it's not being made in an open meeting. The applicant is not present at that interaction, and the applicant may have either a different view of the comment being made or may have an answer to it. So again, the whole concept of this is all the information should be brought forth to the entire commission in an open meeting, with at least the applicant being invited to attend, either by himself or a representative, members of the public being invited to offer comment, hearing from the consultants, having city administration here. And that's another thing I wanted
Well, to that point, Mark, I was wondering, I was gonna ask the commission if there's, if you hear concerns, you wanna, kind of vet some of those things out, you can always ask me, because we usually know. And, I know on one of the applications, there was, trees removed improperly, and sometimes those are rumors, sometimes they're not, but I try to prepare myself for this. If you check with me, I can at least let you know that there's maybe been a proper, a tree removal permit. So you got the planners you can ask questions to, but from the administration standpoint, you can ask us, because most of the time we'll know those. And my fault, there's time, sometimes I will interject and clear the record, or clarify it, to clear the record, but sometimes I don't necessarily do that. But, only last point I wanted to make is if anybody needs some additional information before the meeting, just actually contact Amy, and we'll provide it for you, whatever you need.
Or if something's
More
not
plans, bigger
clear.
plans, or whatever you need, we'd be happy to do that.
And that's actually, contact the administration if something's unclear. If you got questions regarding background information, I encourage you not to contact one another, but you can always reach out to the administration. And the other point I wanted to make, I almost forgot about, in making your motion, you may, as the chair, before you call for a vote, just take a look over here. Dave brought up an excellent point that, sometimes the motion that's made is effective in dealing with the motion, but it's going to be difficult to implement practically. And so he may want to add some input into clarifying your motion so that when he goes to apply it in the field, it's easier for him to apply. So,
Yeah, we talked about that, so.
So what I'd like to do is thank you for your presentation. I just want to summarize in 1 minute what I heard. so that we're all on the same page. So procedurally, a couple of things. During our meetings, now, I'm going to basically do my intro the way I normally do, but as a group, we're just gonna make a practice of, even though I sometimes say it, that I will say that we're gonna wait until the conclusion of the planners and the engineers, that we're actually gonna do that, and hold our questions. We'll look to the applicant for their input, get communication from anyone that's in the audience. We're gonna come back. As long as I'm sitting in this chair, I'll do my best to acknowledge people and look for them. We'll have a responsible conversation where we're not talking over each other, but I don't think we usually do that. You know, sometimes we do, but I don't think that it's like a huge issue. And
And I'd like
with-
to make the point, I don't think we do sidebars like you were, I've never noticed that being an issue, but.
But he made his point, but
I
just,
was asked to come here and provide training.
Oh, I appreciate
That's
that.
one of the points that I
Okay.
always raise in training, so.
Great, I appreciate that.
If it doesn't apply, ignore it.
Okay.
so, and then to summarize, when we do our motions, we'll just be thoughtful in the process. Once something's on the table, I'm gonna look to you, David. If you've got something, if Will's sitting there or Connie's sitting here, she can nudge me, he'll kick me or something, I don't know. But, we'll follow that practice. As law, we should not do any, like, deliberation on any issue outside of a meeting. Contact is permitted under what happens under the Open Meetings Act, but we shouldn't make a practice of that. And I think it's all good. Is that good? Cool. Now, do you have like dessert for us, or? All right. So unless there's any further comment, can I adjourn?
Please do.
Yes. Okay, thank you.
Thank you.
Thank you.